What's up, everybody? Welcome back to part 4 of my review of the state's response opposing a motion for post-conviction relief to Steven Avery. This is the state's response to Kathleen Zellner's latest filing on behalf of Steven Avery in an attempt to get him an evidentiary hearing. We're back with part C, direct connection. Direct connection is assessed by considering the evidence in conjunction with all other evidence to determine whether, under the totality of the circumstances, the evidence suggests that a third-party perpetrator actually committed the crime, and take the defendant's theory beyond mere speculation. No bright lines can be drawn as to what constitutes a third party's direct connection to a crime, but it must be more than a connection between the third party and the crime. It requires some direct connection between the third party and the perpetrator of the crime. Thomas Lewinsky states that he saw Bobby Dassey pushing a RAV4 on November 5th. Do not provide a link between Bobby Dassey and the perpetration of the murder. No, that doesn't show that he's trying to get rid of evidence, like, not even a little bit. At the most generous, the exhibits Avery has submitted could establish that Bobby was involved in moving the RAV4 to the location where it was eventually found. That's exactly what it shows, because he was, man, there's nothing more than a possible connection between the third party and the crime. It provides no link at all between Bobby and the perpetration of the actual killing. It also does nothing to establish that Avery was not the killer. Even if believed, all Lewinsky's evidence would show is that perhaps Bobby was involved in trying to cover up Avery's crime. Man, after all, Avery recruited Brendan to help him try to cover up his tracks. That hurts my brain so much. The same could be true about Bobby. Nothing Thomas Lewinsky states connects Bobby to the actual killing in any way. Direct connection requires showing that under the totality of the circumstances, the evidence suggests that a third-party perpetrator actually committed the crime. Avery's multiple layers of conjecture piled on top of an allegation that Thomas Lewinsky maybe saw Bobby pushing a car, similar to the victims at some point, do nothing to establish any fact that's showing that Bobby actually murdered the victim. Nah, it's just some other RAV4 that he was like pushing around there, you know? Just completely unrelated. In short, Avery's claim that the Denny requirements are now satisfied is wrong. The tendency that Bobby committed this crime, based on what Avery has presented here, has not even entered the ballpark of legitimate. Neither is what they have stated here either. Just throwing that out there, if that's what they're going with. Avery's allegations are conjecture and speculation plugged into and accounted for periods of Bobby's time. That is insufficient to meet Denny. The facts in Avery's motion necessary to establish Bobby's motive or opportunity to commit this crime and then carry out an elaborate planting scheme along with nothing tying Bobby to perpetration of the actual killing means Avery has failed to establish a legitimate tendency that Bobby was the killer. Avery thus failed to meet his pleading burden on both his newly discovered evidence and his Brady claim. No hearing is necessary. Avery is not entitled to an evidentiary hearing on his newly discovered evidence claim. Avery's newly discovered evidence claim is multi-layered. To be entitled to a hearing, Avery had to plead sufficient facts to establish not only that Lewinsky's alleged testimony would have allowed him to meet the Denny test, which, as explained above, it does not, but to also sufficient facts to establish that if he had presented his third-party perpetrator defense at trial, a jury would have had reasonable doubt about his guilt. He has not done so. I disagree. Defendant must meet a 5-part test to obtain a new trial based on newly discovered evidence. To set aside a judgment of conviction based on newly discovered evidence, the evidence must be sufficient to establish that the defendant's conviction resulted in a manifest injustice. When moving for a new trial based on the allegation of newly discovered evidence, the defendant must prove by clear and convincing evidence that the evidence was discovered after conviction. The defendant was not negligent in seeking the evidence. The evidence is material to an issue in the case. The evidence is not merely cumulative. If the defendant is able to meet this showing, then the circuit court must determine whether a reasonable probability exists that a different result would have reached in trial. My opinion, they have, but again, my Netflix law degree doesn't mean anything. A court reviewing the newly discovered evidence should consider whether a jury would find that the evidence had a sufficient impact on other evidence presented at trial, that a jury would have reasonable doubt as to the defendant's guilt, whether the court must consider the new evidence as well as the evidence presented at trial. The court is not based its decision solely on the credibility of the newly discovered evidence. Instead, the court must ask whether a jury presented with this evidence, regardless of lack of credibility, would have had a reasonable doubt whether the defendant's guilt when considered along with the evidence presented against the defendant at trial. Again, I absolutely think there is reason to believe a jury may have gone a different way with all of this evidence. The state disputes that the evidence submitted is material for the reasons explained above. Even if Avery could meet the first 4 prongs of the newly discovered evidence test, though he cannot, shows that his evidence would cause a jury to have reasonable doubt about his guilt. Because Avery failed to plead facts that would sufficiently establish the 3 prongs of Denny, his allegations that Bobby was the perpetrator would be inadmissible in a new trial. If the newly discovered evidence presented by a defendant would be inadmissible at a new trial, there is no way it could have an impact on the jury's evaluation of other evidence, and the defendant fails to meet the burden. As Wilson makes clear, the Denny test is a 3-pronged test. It never becomes a 1 or 2-pronged test. If a defendant fails to make an adequate showing of any of the 3 prongs, the third-party perpetrator evidence is inadmissible. And as the state explained, Avery failed to meet his burden on all 3 prongs of the test. But even on motive, his opportunity evidence is flatly insufficient, that is, to establish that Bobby could have committed the crime or staged the crime scene, and his direct connection evidence doesn't establish a connection between Bobby and the actual killing. Accordingly, no jury would ever be presented with what Avery has submitted here, and therefore there is no possibility that it could affect the outcome of a new trial. Even if this evidence were admitted and the theory of defense were presented, there is no reasonable probability of a different result at a new trial. Again, what a ridiculous thing to say. Even assuming that this was sufficient to meet the Denny and Avery had a new trial presenting this defense, hey, he didn't in brackets in this section like they did in all the other sections. This defense instead of the police bias defense, there is no possibility that any jury hearing it would have reasonable doubt about Avery's guilt. I strongly disagree. As explained above, there are far too many inconsistencies between Avery's allegations about Bobby Dassey and the actual evidence produced at trial. Avery's complete failure to account for his DNA on the hood latch, that they have very much accounted how that DNA on the hood latch got there. Love how they just ignore how they actually did that. Of the RAV4 and Mrs. Halbach's remains, again including a fragment from virtually every bone in the human body being found in his burn pit. I'm going to assume that Kathleen Zollner is going to respond to this and actually tear that part apart. And nothing to explain how Bobby could possibly be responsible for the bullet with Mrs. Halbach's DNA on it being found in his garage and matched to the gun above his bed. Avery's new defense would essentially be asking the jury to ignore the forensic evidence introduced against him when presented with the common sense that the evidence was located where it was because Avery shot and killed the victim and then attempted to hide the evidence of his crime, versus Avery's attempt to paint Bobby as a porn-obsessed, scientifically savvy, and extraordinarily stealthy criminal mastermind who inexplicably wanted to frame his uncle. No one would have a reasonable doubt about Avery's guilt. Courts may permissibly find as a matter of law that no reasonable jury could determine that the third party perpetrated the crime in light of overwhelming evidence that he or she did not. Here, overwhelming evidence that Bobby did not commit this crime in the utter absence of any facts tying him to the actual killing or to even a single piece of the forensic evidence. Avery's theory requires so many speculative leaps, ignoring the actual facts of the case, that is reasonable moviegoers would be hard-pressed to sit through. Any reasonable jury being asked to search for the truth in a murder trial would reject it without fail. Avery has failed to plead sufficient facts to establish a violation of Brady, and the record conclusively proves that he could not do so, so no hearing is necessary. Avery failed to provide sufficient facts to establish this audio clip's materiality. Under the 14th Amendment, suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material, either guilt or to punishment of the good faith or bad faith of the prosecution. The evidence must be favorable to the accused, either because it is exculpatory or impeaching. It must have been suppressed by the states either willingly or inadvertently, and it must be material to the defendant's guilt or punishment. Evidence that is material and therefore must be disclosed only if there is reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. It would have, in my opinion. A reasonable probability is probability sufficient to undermine confidence in the outcome. However, showing that the prosecution knew of an item of favorable evidence unknown to the defense does not amount to a Brady violation. It absolutely does. Without more, and a defendant's request for Brady material does not require a prosecutor to wade through all government files in search of potentially exculpatory evidence. Importantly, for the issue raised here, Brady does not require the prosecution to disclose evidence that is merely potentially exculpatory. Man, they know that call was there, but they do not want that admitted in court. Stated differently, the state is not constitutionally required to turn over the type of information that could form basis for further investigation by the defense. Oh, wow. Avery has again failed to meet his pleading burden because it has not submitted anything that would establish an actual Brady claim, even if true. There are several glaring failures with what Avery has presented. First, Avery's dogged insistence that Bobby Dassey was the state's primary witness against Mr. Avery at trial remains false no matter how many times he repeats it. Bobby established only that Teresa Halbach arrived at the Avery salvage yard on the day in question, and that he saw Teresa Halbach walking towards Avery's trailer shortly before she disappeared. The state's 16 law enforcement witnesses and 12 forensic scientists who explained the enormous amount of forensic evidence pointing directly to Avery as the killer were all far more material than Bobby, and Avery fails to explain how attempting to impeach Bobby with this evidence would have turned the tide at the trial. Second, Avery's submissions are insufficient to establish any facts related to this claim. Avery has presented nothing more than an unauthentic piece of paper on which some identified person apparently typed their interpretation of what was said in an audio clip at some unidentified time. Absent from what Avery submitted to this court is only a copy of this audio clip, let alone any documentation about when it was received by the sheriff's office, who transcribed this clip, when they did so, what they were using as a reference, any timestamps or anything else that would provide some verification that what Avery submitted is actually true and accurate. It is a bare piece of paper with some words typed upon it. That is not evidence. Assuming that everything Avery submitted is accurate, though, he still hasn't established that this was material evidence that was required to be disclosed to the defense. There is literally no details contained in the audio clip that would indicate that Thomas Sawinski had material exculpatory information. Thomas Sawinski said nothing other than he had something that he didn't know if it was good information or bad information about the girl who was missing. That is everything contained in the audio clip. Nothing in those few sentences could have conceivably been considered material exculpatory evidence that the prosecution should have been on notice to turn over, and indeed Avery actually does not attempt to argue that the contents of the phone call are materially exculpatory or impeaching. What he argues is that the defense had been provided with this snippet of audio, they could have tracked down and interviewed Thomas Sawinski, which is 100% accurate. But that does not make this phone call Brady material. It makes it an avenue of investigation that could have led anywhere, which is insufficient to establish that it was exculpatory. And significantly absent from attorney Jerry Buting or Dean Strang's affidavit is any allegation that they would have pursued Avery's new Denny theory if they had Sawinski's new information. They say that only they would have pursued the information that Thomas Sawinski called the sheriff's department diligently and would have made a specific request for further information about the substance of that call. There is no allegation that they would have attempted to present this theory that Bobby Dassey was somehow responsible for the murder, either at the pre-trial Denny hearing or at trial, if they had spoken to Thomas Sawinski. And it is easy to see why no reasonable jury would have believed it. The police frame-up theory was far more the police frame-up theory was a far more believable defense. Again, evidence is only material if there is a reasonable probability that it would have made a difference in the outcome of the trial. A defense that would not have been presented would not have made a difference in the outcome of the trial. Therefore, Avery's affidavits are insufficient to establish fact to support a Brady claim. So all Avery has argued that if he'd been provided this phone call clip, he would have had information that could have formed bias for further investigation. That is insufficient to state a Brady claim. Okay, this one got a little bit longer. There's a lot of information there. I'll be back with the next part shortly. Let me know what you think of everything leading up to this point. Leave some comments below. I hope you're having a good day, and I'll see you again soon.